an amendment to Information Technology Act. And 2006, the amendment bill was presented. At that time, a bill on data protection also was presented. It was called Personal Data Protection Bill. Subsequently, ITA 2000 amendment was passed. It became the ITA 2008 version. But this 2006 data protection version did not go through. In fact, at that time, with the KLE Law College, we had done a big program in Bangalore on that privacy bill. After that, 2006, until around 2015, India had not done anything on privacy. But then when after the current government came in, they started using Aadhaar in a big way. And that generated some questions on whether Aadhaar is leading to infringement of privacy. Therefore, Justice Puttaswamy, whom actually FDPPA recently honored as Privacy Pitamaha. Everybody has forgotten him. Actually, he was the person who actually initiated the action towards what we call today as DPDPA 2023. Okay, he had filed a case about the probable inappropriate use of Aadhaar in a manner in which it could infringe privacy. That was his contention. So Supreme Court at that time constituted a bench, and in 2017, the bench gave its decision that is actually referred to as Puttaswamy judgment. So that initiated another round of laws. In 2018, Justice Sri Krishna Committee had presented a draft. Then 2019, another version, DPA 2021, third version, and then now this 2023 Act. So a lot of action has taken place in the last 4 or 5 years, and we today have this particular law. So we will discuss how this law will be of interest to you. Can you move that? You move it in the laptop itself. Okay. The first question which people like you would be having in your mind is that you are a cost accountant, and of course the management accountant, as you call it now. In our times, we were calling you as cost accountant only. Now you are talking of CMA or something like that, cost and management accounting. It's good. I was I'm a DM person, that is All India Management Association MBA. No, back, yeah. Okay, so as a cost accountant, the first question for you is, in what way is this data protection relevant for you? See, unless we accept this, the interest would not be there. There are information security professionals, CISOs who are interested, fine. You are not one of them. You are also not a legal professional. In organizations, there are CCOs, Chief Compliance Officer or something like that. Maybe you are partly associated with business as a consultant. Many of you are company secretaries. Company secretaries are key people in corporate management. But still, you are not directly today associated with this concept of data protection. That is one. Second, most of you may be associated with manufacturing companies, whereas the data protection is more discussed in the IT sector. So that's also one of the reasons why maybe you have not gone deep into it. But what I would like to tell you is data is today considered as a business asset. Okay. It is therefore relevant for you to understand data because you are the people who are looking at asset, what is its value, how the value changes, what is the cost, how does cost reduction helps in revenue generation. Okay, this is a purely a specialized area. But if you look at data today, data is itself a very valuable asset, and it has all the requirements of management which you perhaps would like to do for any other asset. Plus, there is a profession which is coming up called data audit. After this act comes, there will be one class of companies called significant data fiduciaries. Okay. And for significant data fiduciaries, it is mandatory to have an external independent data auditor appointed. What is his role? His role is to look at whether the organization is compliant with DPDPA 2023. So directly, he is the person who will audit the company's operations with reference to this act. Okay, this is a legal kind of an audit, you can say, but it is not purely legal, it is techno-legal audit. Okay, and that is going to be mandatory for companies which are going to be classified as significant data fiduciaries. Government may tell us what will be the criteria on which they will decide who is a significant data fiduciary. And the understanding presently is that in order to ensure that this act is implemented in a modular fashion, initially government will take one set of companies and say you are significant data fiduciaries, that is the large companies. Then others may be slowly brought into the particular criteria. That is what perhaps government will be doing for the purpose of implementing this act over a period of time. So even after the rules come, which is expected in the next 1 week or 10 days, even if the number of significant data fiduciaries according to this rule is less, please be assured that in the coming years, it will keep on expanding. One after another, different sectors will be brought in. So there will be a lot of companies which will be coming under the category of significant data fiduciaries, which will be requiring this mandatory data audit. I expect that to be a very good area for professionals. Okay. Now, if you look at the nature of data, there is a cost of acquisition for the data. See, today data, we said in every company, you said companies are led by data. See, earlier data was only considered as an information which will help us to take better management decisions. See, when we all started looking at the corporate usage of data, in fact, when I did my management this thing, one of the project which I did was the management information system. Okay. Now, at that time, the idea is if there is computerization, if there is information about the operations of the company at the tips of the fingers of the managers, your business decision making will be better, the efficiency. Okay. But from there today, we are saying companies are data driven. That is, today data has become much more than just an assistance for business decision making. In fact, data itself is a raw material. It gets value addition and then becomes finished goods, and there is a sale happening. And one advantage of this data assets is the same data you can sell to 100 people. You still have a copy. In a manufacturing company, when you produce, you have to produce 100 times the same product. But here, if you have one successful product, after all, that is why software companies are making money. Okay, they produce a good software once. Then they sell a million copies of that software. Okay. So that is the advantage of data as an asset. Okay. So there is a cost of generating. Software itself is the data. Okay. Apart from that, the data of say production data, marketing data, and in the context of what we are discussing, individuals information, which we call as personal data. Okay. They are all different kinds of assets. A company will have a personal data of people. Maybe they may be employees. They may also be customers. Every manufacturing company, if you are in, let us say, Toyota, it is not a question of this 20,000 employees. I don't know how many employees are there in Toyota, maybe 20,000, 30,000. That is their data. When we say data, we're talking of their name, address, PAN card number, etc., and their family members' name, address, etc., because many times we give some benefits to the family. This is all personal data of employees. Plus, we have got dealers, customers walk into the dealers' showrooms. Every dealer's showroom has got a CCTV. When it captures the person walking in, it is capturing personal data. So every manufacturing company also collects lots and lots of personal data of outsiders. Now, all of that comes into this particular jurisdiction of this particular act, and there is a value to that. Okay. That is why there is a whole branch of business called data analytics and big data, which tries to generate value for the data captured in various situations. So there is a cost of acquisition, cost of generation, and when data is converted, for example, you get data from 1 million people and then do a filtering and then generate what we call as insights, marketing insight or something like that. You are creating a value added data. These are all the characteristics of this asset. I feel that this asset has got both the characteristics of a fixed asset as well as a current asset. See, what is a current asset? Current asset undergoes a change in the life cycle and becomes a marketable asset at the end of the life cycle. In a fixed asset, the fixed assets remains like a catalyst and it helps in the generation of revenue. Now, in data, you take the example of a portal. Okay. What is a website? Okay. Website keeps on having a collection of articles, information, and other things. Okay. That is the content. That is also data. You build that data for which you spend money. So there's a cost and you create a portal. How do you generate revenue out of it? You have advertisements coming out of it. So the asset remains the same, but as the asset grows, the potential for monetizing that by way of advertisement grows. This is where data is like a fixed asset. It becomes the basis on which revenue can be generated. If you take large companies like Twitter or Google, their existence is only because of that. They give you free services, okay? And by using the free service, you actually pump in a lot of information to them, and they do a lot of data analytics on that and create some kind of good, say, insights. And through that, as well as through these advertisements, they will be able to generate money. So data in that context is used more like a fixed asset. I call personal data as a category as similar to an hazardous asset in an industry environment. Say if you are having in the industry an inventory manager, sometimes some chemicals or something like that, you have to treat it differently. You may have to have a specialist in a specialized godown to manage that hazardous asset, because the risks associated with storing and usage of the hazardous asset is much different from other things. Steel, this thing, you can put it in the yard, in the open sun and other things, but you may not be able to do it otherwise. Same way, the personal information is a hazardous asset for the reason that whether we like it or not, there are a lot of regulations associated with the personal data. And these regulations say if you don't follow the regulations, there will be heavy penalties. That is the risk. In a hazardous chemical, it may be a risk of explosion and other things. Here, it is the risk of penalties being levied because of regulation. You have heard of the term GDPR. GDPR is a general data protection regulation, which was initiated by the EU. And one of the penalties which was levied under EU was equivalent of 1.2 billion US dollars. Okay, 1.2 billion US dollars may come to nearly a lakh of crore kind of a thing, 8,000, 9,000 crores per billion, 10,000 crores. Okay. In another case, Amazon was fined for 887 million US dollars. That is the kind of penalties which GDPR is imposing. Okay. In India, whatever law we are now talking of is still not in the thousands of crores area, but it could be 200 crores, 250 crores, 300 crores as penalty. It is no longer 5 lakhs, 10 lakhs. It is not even 1 crores, 2 crores, which we have started seeing now after the telecom industry and other things came. Maybe you are getting into penalties in terms of crores. But we will be now talking of hundreds of crores. I don't think many of our companies are capable of taking such heavy penalties if it happens. Okay, I hope it will not happen. Regulators also will be very careful. They are not going to kill the industry. Even when they have any reason to have penalty, they will actually have a nominal penalty to start with. There is also a provision here called voluntary undertaking. What we mean by voluntary undertaking is in criminal law, you have heard of plea bargaining. That is, you agree that you have made a mistake, your penalty will be very much less. In fact, the latest Indian Penal Code has introduced the community service as a possible penalty. It was not there in Indian law earlier. So many times, many of us make some mistakes. Okay, not intentionally sometimes, sometimes for whatever reason. And even for 1 month, 2 month jail term is not a fair thing. So this community service is, at least in many cases, I think is a far better way of reformation. And we have tried to adopt that. So this is the kind of scenario which we are coming in. DPDPA has introduced this voluntary undertaking where if a company having made itself liable for this 200, 250 crores, perhaps pleads with the authority, there will be an authority called Data Protection Board, and says that we will try to correct whatever mistakes we have done, probably they may waive off the penalty or have it at a very nominal level. Okay, so government as well as this board will be very considerate to the industry. But however, it is there. Let us remember that if you are compliance managers in an organization, we have to keep the board informed that this is the risk. Non-compliance of DPDPA is a 250 crores risk. Okay. In fact, that is why I say that in companies, even before the CISO or data protection officer talks about the risk of DPDPA, it is the CFO who has to flag this risk. The CFO has to say that a new law has come in India and I don't know what we are supposed to do under the law, but I know that if we don't do it properly, then 250 crores I have to put in my budget. Okay, so the trigger for compliance has to come from the CEO and the CFO. Okay, that is the 250 crores risk I am talking of, which this DPDPA 2023 is introducing. Okay, along with this, India already had this Information Technology Act 2000. whenever a non-compliance of this DPDPA occurs, I can always say there is a non-compliance of ITA 2000, because that is also data management. This is personal data management. If there is a personal data breach, it is also a data breach under Information Technology Act. If there is a misuse of personal data, it is an offense under Information Technology Act. Information Technology Act is a criminal law. It has got the punishments starting from 1 year to life imprisonment. Okay. And it also has a provision of escalating the punishments which should be there to a corporate to the executives. That is where this Avnish Bajaj was caught. See, Bazi.com had a customer who actually used the network to commit an offense. Okay. But the law did not stop at punishing that one particular person, that IIT Kharagpur student. It asked a question to the company: where was your due diligence? What steps you had taken to ensure that this crime does not happen? Compliance. Okay. Whatever they said, court did not accept. They said it was not sufficient. Because your due diligence was not acceptable, the CEO of the company and the general manager of the company were subjected to the same punishment which was given to that student who actually committed the offense. This is what we call as a vicarious liability provision, which is there in Information Technology Act. Therefore, we cannot simply say that, okay, 250 crores, my company is a 10,000 crores company, it will handle the 250 crores. Okay, if Google can handle 1.2 billion US dollars, my company can handle 250 crores. It's not like that. If I invoke Information Technology Act, then the CEO, the directors, maybe the chairperson, the person in charge of business, okay, that is where this general manager of Bazi.com was there. So they are personally liable for imprisonment, not for just penalty. Penalty company may pay. Okay. So the non-compliance of DPDPA may roll over to be the non-compliance of ITA 2000 and also this new IPC, both of which will be introducing the penalty in terms of criminal aspects. That is where, if we are in the company, we have to be careful. If we are advisors to the company, we should remember that that is one of our responsibilities. So, pardon? Any data which relates to an individual, okay, in the custody of an organization. Now you are an NGO, your association. Do you have personal data with you? Do you have personal data in your organization? Yeah? You have, no. Say your 10,000 members, personal data you have got, and anybody else with whom you interact. So you have got their name, you have got their address. These are all the personal data, this thing. You have got their phone number, you have got their PAN card number. You may have Aadhaar number in certain cases, in certain other businesses. You may, in a hospital or something like that, you have got a health report. In a college, you have got the education report. In a bank, you have got the finance report. All these are personal data. Personal data is any information which is identifiable with an individual. We say living individual, but sometimes even dead individuals are also important for us, because our DPDPA talks about nomination of personal data. I don't know whether your membership can be nominated, but the data which you are having becomes part of nomination. Nomination will happen only after a person is deceased. So that is why part of this new act will be applicable even for deceased persons. Otherwise, normally this kind of act is supposed to apply only for personal data of living individuals. Okay. Any questions anytime, you please arise. Yeah. Yeah. Yeah, yeah.
IPO.
Mm.
The resulting of I have not succeeded that IPO.
Mm.
Okay.
Mm.
They have refunded the money.
Ah.
After 1 week, I received a message from Tata Capital.
Mm.
They are indirectly influencing me to come for deposit with Tata Capital. So this is what kind of that data, how they can use my data, where I applied for IPO, why they are approaching me for Tata Capital to come for investment. On what basis I can go for that file a case against this Tata Capital?
Okay.
Because this is relevant to your.
No, definitely. I will address that when we are talking of consent. Okay, I will come to that. Ramesh? I will come to that. I will come to that. Okay. Yeah. See, another aspect which we must all remember is about the nature of data. What is this data? I said it is an asset. Okay. Now, data is binary. Technology people will say data is binary, zeros and ones. Okay. Nowadays, you have this kind of pictures. You call it as QR code or something. That is also data. Okay. Because there is something hidden there. In fact, many of the cyber crimes happen because of that. Okay. Because you don't know what is there. You just hold your mobile and it may read. Okay. Now, data, therefore, may appear to be in the form of zeros and ones or in the form of this coded kind of things. Now, as a human being, zeros and ones you don't understand, even that QR code, your eyes will not give you any meaning. But if you use a particular, next please. Okay, if you use a particular application, this QR code will get translated into a text. In this particular case, it says data is in the beholder's eyes. Now, these words are embedded in that QR code. So the QR code, which looks like a beautiful picture, is actually a binary data because it takes that canvas, divides it into pixels, pixel 1 dark, pixel 2 white, pixel 3 white, something like that. It identifies that canvas as space which can be designated, and that is how it becomes binary data. And this zeros and ones, next please, zeros and ones also is like that. Zeros and ones, if you use a what we call as an ASCII viewer, okay, you get some words. Here it is, data is in the beholder's eyes. If you use a numeric converter, it will convert into a number. Now, therefore, the zeros and ones, if somebody asks you, what is this? Either you have to say, I am a human being, I don't know what it is. Okay. But if you use appropriate conversion devices, human beings will actually get meaning out of it. That is why I say data is in the beholder's eyes. What you call as data, we call it as an asset. It is a meaningless asset unless a human being puts meaning into it. That is why data value comes along with the human input. Say, look at an X-ray sheet. If I and you look at the X-ray sheet, you'll say it's a negative, black, white kind of a thing. We can't make anything out of it. But if a doctor looks at it, he gets a lot of meaning out of it. It is like your modern art. I and you look at modern art, we may not appreciate it. But maybe an artist may say how beautiful it is it not? So you can't deny that maybe he is seeing that beauty there, which we are not seeing. Likewise, data value is embedded with the person. That is why value of data is context-based. Now, if you are a cost accountant, tomorrow you are asked, what is the value of one address? Okay. If that address is of some unknown person, it has got some X value. If the address is of some very important celebrity, it has got a different value. Is it not? Telephone number of me or Ramesh has got some value. Telephone number of Shah Rukh Khan or somebody has got much more value. Okay. So data valuation has to be looked at from the context. So if you are a brilliant cost accountant, you have to look at this. It's like your valuation of precious, you can say stones or something like that. I may look at it and say, this is like a glass. Okay, I can't make a distinction between American diamond and the real diamond. Okay, but valuation can be vastly different. But if you are an accountant, you have to find out somehow what is the difference. If necessary, call another expert. Okay, data valuation is also like that. That is why I say this understanding the nature of data is important, and the valuation of data is associated with the creative view of a human being. Next, please. Okay, and if you use appropriate software, appropriate operating system, etc., you can convert the zeros and ones into the human experience of what we see, what we hear, etc. Okay, this is a fundamental understanding of data we should have if tomorrow we have to look at what is this act, what is it saying. You asked about the question of personal data. I'm talking of data itself. There's so much of complications. Okay, then what is personal data? Okay, if I say chi, is it personal data? Could be Chinese have this system. In China, chi may be a name. Okay, so for I and you, it may be a curse word, chi, we say. Okay, but it may be a personal data. So if I and you classify that, we will not classify it as personal data. Okay, but if somebody who is in the context, you say chi and chi came to India, maybe you have to put it as a personal data. Okay, so that is why understanding of data is a very complex issue. And though we say it about an individual, who is an individual, whether his name gives identity of the individual, or is there any other core identity? If you say Vijay Shankar, there are 100 Vijay Shankars. Okay, so the name Vijay Shankar itself is not a personal data, identifiable personal data. If you say Vijay Shankar living at such and such an address, maybe it adds more. That is why with each additional parameter associated with an identity, personal data becomes more and more identifiable, more and more valuable. So in terms of costing or valuation, you have to look at the depth of data. Okay, and width of data. Okay, name with XYZ parameters, it gives a width. Then the depth in terms of how much information you have got, that also becomes important. So valuation of data, understanding of data has these kind of issues. Otherwise, generally we can say data has got a value which can be monetized. Now with this basic thing, let us take a bird's eye view of this act. I will only talk of general aspects. Then we can go into some discussions. It has got about 44 sections over 9 chapters and one schedule. The essence of DPDPA is that organizations which collect information, personal information, and use it for some purpose, okay, they have to have some legal obligations. Okay, basically the whole act is called Digital Personal Data Protection Act. Okay, that is, it applies only to digital personal data. It does not apply to non-digital personal data. Fine. Okay, and in this, only thing it says is whoever collects personal data, whoever processes personal data. Processing is a broad word. It includes storage, it includes transmission, it includes adding 2 pieces of data and creating more. Anything, any rearrangement of binaries is a processing. Okay, so anybody who collects personal data or processes personal data is given a list of things to do and a list of things not to do also. And that is what we require, call as obligations, and non-compliance of that is what results in penalties. So what are our obligations? What will happen if we don't do that in terms of penalties? These are the 2 important things which we as corporate advisors need to look at. Some of you are looking at it as he was telling about personally what I will get. Okay, like how did they get my data, whether there was anything. Okay, we'll come to that. That is embedded in the obligation of the organization which takes that data, how they should have used it. Okay. One thing which you will find in most of the industries is people say, I am already GDPR compliant. When I am compliant with some EU law, what is this Indian law? India is a small country. Okay. So many people have a feeling that I can ignore Indian law. But there is a big mistake to make. India is no longer a pushover. Okay. Is it not? We are going to be the fourth economy, maybe going up to the third or second. Yeah. Okay. And of course, our attitude also has changed, that we no longer are a colonial power. But still, in many corporates, this thinking prevails. And you will also hear it when you go to your companies and say that India seems to have done this. The first thing you have to ask your management as a company secretary is, have we done a assessment, business impact assessment? Some new law has come. How does it affect my company? This has to be done by the board of directors, nothing less than that. Okay. I don't know, some of you may be even independent directors, or at least you are in a position to talk to directors and give them. This first thing you have to ask, in your company, have you done a business impact assessment? Just to think, does this law apply to me? Do I have any risk? Then how to get over that is a different issue. Otherwise, it will be dereliction of duty of an advisor. Okay. So one of the things you will hear immediately is, we are GDPR compliant. We are ISO 27701 compliant, both of which have got no relevance for DPDPA 2023. Okay. A strong statement to make, I will make that statement. Okay. I don't mind because I can justify that. If you are ISO 27701 compliant and ask me, should I do anything more in DPDPA because I have done that? I say, yes, you still have something because they were all created for something else. So it is like Sunil Gavaskar was India's legendary player. Okay. But tomorrow against South Africa, if you are selecting a team, will you select Sunil Gavaskar as the opener? Or will you select somebody else, Ritu Gaikwad? Sunil Gavaskar's days were there and it was over. We respect that. Likewise, ISO 27001 days were there. It is over. 27701, another context, it was important. Okay, over. But don't tell me that that is relevant for DPDPA. Okay, this requires a lot of conviction and courage. Otherwise, it's very difficult. Okay, fine. So the risk of non-compliance, I said 250 crores, 200 crores and other things. I have already given that. Now the collateral risks also, I said that it is not only DPDPA. I think you have to go ahead. Okay. This is the collateral risk. I said ITA 2000 risk, IPC risk, they will all get added on. So please remember that. Next, please. Okay. Now, why I say ITA 2000 is important is, you are asking that if Tata has asked for my information for IPO, you have given. At that time, they were expected to ask you that for the purpose of your IPO application, I want your name, address, etc., email address. They should have asked you that I will use the same information for giving you some other corporate benefits like our deposit schemes. Do you agree? If they had asked for that and you had given yes at that time, that is called the consent. That is, if they had taken a consent, consent is always purpose-based. Okay. They took your consent for application to the IPO. If they wanted to use it for something else, they should have asked that in case your application is not successful or I have to give a refund, can I propose something else, some other product to you? Then they would have had consent. Maybe they would not have taken the consent.
The SEBI is controlling everything. That how they come for this option. Whether I paid in the IPO allotment, they will go for another option of another Tata group who can use that my information for that their purpose. That is totally wrong, no?
No, it is, that's what I'm doing. See, if they wanted to do that, they should have asked their permission, that is, their consent should have been brought. If they had not done, which probably they would not have done, okay, it is wrong. Now the question is, what is the remedy for you? That's what you are asking, is it not?
Yeah.
What is the remedy? Can you claim compensation from Tatas is what is in your mind. Am I correct? Okay, can you file a suit, he said. What DPDPA says is, we already have something called Information Technology Act. Now we are coming with DPDPA. In DPDPA, we will tell Tatas what they should have done. Like, if they have not taken your consent for marketing other products, Tatas has made a mistake, for which the Data Protection Board can impose penalties of this 100 crores, 50 crores, whatever is that. That is what DPDPA says. Does it say that 100 crores will come to you? No, I'm telling you. That's what I'm telling you. That is for non-compliance, whatever penalties are prescribed, it goes to the government.
But 1%
At present, it is not there. Okay. No, but I'll tell you. But so under DPDPA, you don't have any personal remedy. But Information Technology Act has got your remedy. That is why I say that Information Technology Act immediately should think. Information Technology Act has a provision that in certain cases, which you can fit this also into that, there is somebody called an adjudicator. If you have suffered any loss, you can claim compensation for that loss under Information Technology Act. But when we use the term compensation, compensation is only against a loss. If you have not suffered a loss, you cannot claim compensation. So you have to prove that you have suffered a loss. Then there is a legal remedy under Information Technology Act, not under this. So whatever is that, you call that also as your loss, doesn't matter. I'm saying that provision is available in ITA 2000. That is why DPDPA is closely associated with ITA 2000, particularly in respect of data principles right to remedy. It is not available here. You have to go here. It is like even in our IPC or something like that. Let us say cyber crime, any crime, you go and file a police complaint. Police are not obligated to give you money for that. Okay. They will find out the culprit and punish that culprit and maybe collect a fine. That fine will go directly to the government. It will not come to you. Okay. Because that is different. But you can always file a civil case for recovery of compensation, even in a criminal this thing. Suppose there's a car accident. Okay. You can claim your compensation. Likewise, here also, don't expect remedy, personal remedy from DPDPA. It is available in ITA 2000. Whether it is adequate, not adequate, whether you are happy or not happy, that is the situation. Okay. So that is for the information. That is why the two are linked together. Yeah.
Technology is responsible or the data capital is responsible? Because we have, like in merchant banking, there are so many intermediaries. We don't know from where they got the data.
Your contract was with Tata Technologies because your IPO was with that. Okay. So that is where you have to start your action. You can give a complaint to the Data Protection Board. Okay. Now, if I say that you are not going to get any remedy, tomorrow you will say, why I should take the trouble of filing a complaint? Okay. That is why in our FDPPI, we wanted to have what is called a data principal reward system. That is, whoever gives a complaint to the Data Protection Board for a valid infringement, okay, and it is accepted or something like that, we want to actually recognize and reward that particular person. Otherwise, I feel that no member of the public will be interested in filing complaints because you know that you are not getting anything, whether Tata or fine 100 crores or 200 crores, unless you have got a vengeance against them, you will not do that. Is it not? So we are trying to suggest that FDPPA as an organization which wants to develop a privacy culture across the country should encourage people to send complaints, because without this compliance, Data Protection Board will not have the information with which they can act. Now, you take a mobile app. I and you know that a particular mobile app is doing a mistake. How will Data Protection Board chairman will know that? This, so somebody has to complain. Somebody, but who will complain? First time, okay, when you're enthusiastic, you will do it. First 3 months, 6 months, one year, you will do it. Afterwards, people will say, I'm not interested. I will do whatever I want. Is it not? So that is why we thought of creating some kind of a reward system, a recognition system. At least we'll put up on their website, we appreciate so and so who has made some complaint, something like that. Okay, just a concept. I suppose you will appreciate that. We have tried to do that. Otherwise, this lacuna, if you call it as a lacuna, remains there. Yeah.
Hold the account, for example, hold the account with HDFC Bank. So what they are doing, they will come and try to sell their HDFC life insurance to me without my consent. I will not, to the best of my knowledge, they have trade cycle every day, which is called credit card, you want this loan, you want this. They do cross selling, which is unauthorized. I am not authorized them to do the cross selling. How does the Data Protection Act fit this?
Under Data Protection Act, the consent has to be taken at the time of collection. And in that consent, they have to say, what is the purpose for which I am accepting your data and how I am going to use this data. All this they have to give what we call as a notice, privacy notice, and then you have to give acceptance. Now, what you are experiencing is information which has been collected before this Data Protection Act came into being. At that time, there was no such great this thing. It was only ethical, but there was no law. Okay, but now there is a law. Okay, so that cannot be done now. Now, what will happen to the data which you have already given? This act says before the company wants to use the data which they have already collected before this act came into force, they have to take a fresh consent. That is, on the legacy data which they are having, they have to at least seek further consent. When they seek further consent, what it means, at least they should send you an email saying that you have given me this data for this particular purpose. I want to use it for insurance marketing. Are you agreeable? You have the option to say no. If you say no, they should stop using it. If you don't say no, they can presume, they can keep on continuing to do that. This is the current law. But anyway, this can go on for a period of about 1 year. Because Information Technology Act says that any such privacy policy consent which has been given almost should be treated as expiring after 1 year. That is, it says it should be renewed after 1 year. Okay. Therefore, by law, if you want to say that this legacy data, the companies need to take a may have to try to take a consent, but most of the time people will not reply. When you get an email, you will not reply. 90% people will not reply. A few people will say no, that they have to immediately action it. Other things they can continue to use until the purpose is over or a maximum of 1 year. Okay, this is my interpretation as of now. Companies will continue to ignore this. Then somewhere somebody has to question them, and then over a period of time, if a couple of companies are put 10 crores, 20 crores fines, maybe people will start using it.
Data of the company stores will give the data, internal data, or will privacy and all that. Sometimes unauthorizedly they use that information for some other activities.
Like what?
Management decisions, labor decisions, hiring decisions, etc. But unethical. They use it the way that they want. They have control of that data, but they use it for some, for example, employee is known that an employee is having some infidelity. He has done some marital infidelity. And one most common example. So many of these companies do not fall within the domain of the company. Now they come to know through third source that this is the case, and go and fire the employee concerned. Now, is this not an infringement of privacy of that employee because he does not concern the service matter directly?
Okay,
So,
no, I take your point. See, employees' data, the employer-employee relationship is different from a company and an outsider relationship. Okay. GDPR actually does not think they are different, and they try to give the same level of protection to employees as they give to outsiders. Indian law does not do that. Indian law thinks that employees are a different category. Why they should be a different category? All corporate confidential information you are anyway sharing with the employees. You don't share it with outsiders. That is one. Second, in this act, there is a provision called legitimate use. So one is consent. That is, whenever you collect, you get a consent. In that consent, you say why you are collecting, how you are using it. You read that, and that the act says it has to be given in 22 languages. Okay, so that it should be as clear as possible. And you can also use an intermediary called a consent manager. So that precaution they have indicated. That is one way of collecting the consent. The second thing is what is called legitimate use. Certain users have been defined as legitimate use. A data fiduciary, that is the person who is processing, should be given the option to use employees' data, first of all, for giving any employee benefits. Okay. Secondly, to have a control on whether the employee is doing anything which is detrimental to the interest of the organization. Okay, like in security, what you do, you try to have a surveillance, you put a CCTV a camera to find out whether employee is working, not working, whatever is that, or whether he is moonlighting with another company. Okay. What you are saying is slightly outside this. Okay. His personal life, whether he has got two wives or a thing, whether it is the consideration of the company, this is something which they have to define as my ethical standards. Okay. So the policy which you have signed with the employee becomes very, very important. Now, I may say that I want my employees to follow certain rigorous kind of ethical standards. Okay. You may not agree. You may say having 4 wives is acceptable. I may say, no, it's not possible. Okay. It may be different. But if your company has got a policy saying that this is not considered good, because it will, if you are disturbed in your domestic life, will it not affect the company? At least I can presume. Okay. So I may have in my corporate policy that we will not encourage that. If that is there, then perhaps I can try to use that. Now, whether it should be summarily dismissed without giving the reason, that is all different. Okay. Probably he should be told, this is our policy, you have violated the policy. That is a better, honest way of doing it. Any other way, which people do, but I cannot justify that, at least in law, it will not be permitted. Okay. So there is legitimate use, but it has to be used with caution. Okay. And these companies in India, we call them as data fiduciaries. What do we mean by fiduciaries? Fiduciaries is like trustees. So they have got a lot of responsibilities. So that is another very special feature of Indian law. It deviates from GDPR. GDPR says he's a data controller. Now we say you're a data trustee. A trustee has got a much different role. If I am your trustee, even if you want me to do something which is not to your benefit, I will say I will not do it. You cannot say that I have appointed you, so please do it. Okay. In fact, company secretaries are in that kind of a state. They are trustees to the shareholders. So many times they will have to say that this is not possible. Okay. Even if your CEO says, you should say no. Chartered accountants also have that role. If they don't do it, like it happened in the case of Satyam and others, chartered accountants also can be penalized. So there is a fiduciary relationship attached to the companies, and that is a speciality of this act. Okay. Now, you must have policies. You must have, you are talking of employee contracts. Now, that is part of this compliance. Now, if you want to do it without agreements, without policies, you are taking that risk. And as compliance managers, that is the first thing you have to do in your organization. Do you have policies? Do you have a HR policy? Do you have a data disclosure policy? Do you have a data collection policy, etc., etc.? There will be maybe at least 30, 40, 50 policy statements which you have to drop. Yeah, you make combine it everything and say privacy policy and information security policy, at least two major policies will have to be there. You can put everything there: encryption policy, transmission policy, signature, electronic signature policy. Right now, there was no law. So let us hope that it will change now. And you are the persons who have to bring that change in the companies. Okay, it will increase your value also as an advisor. When you go to the company and say that this is what you are expected to do, your value as an advisor to that extent should be considered. See, if you make them understand, they will understand. See, who wants to pay 10 crores, 20 crores, 100 crores? Today they feel it is not there, therefore I don't want to do it. When they come to know that the law has come, and you call people like us, will come and explain. The first thing you have to do is have the board members, you should expose them to a discussion like this. Whatever you are telling, let the board members say. You cannot tell to your chairman. I can tell to your chairman at his face, I can say, if you do that, you will go to jail, I will say. Avinash Bajaj has fought 8 years in Supreme Court. Do you want to do it? Advantage of an external consultant is like, is that. I don't think it is supported by law.
And even when someone is on a medical leave or something, the manager will not know what is the illness. So the manager is supposed to ask. That's the end of that.
No, that is why it has to be a policy which your board imposes. Okay, so that you are not personally responsible for that. You have to convince the board that this is required. Okay. If an employee absents for 3 days without information, are you taking any action? You should take action. No, you should have his residential address. You should send a notice there. And if he doesn't turn up after say 7 days, you may have to file a report at the nearest police station saying that this employee was last seen at 5 o'clock on such and such a day in our office. Afterwards, he has not been there. This is a responsibility. Okay, this is what people like us say. Okay, now.
What is the HR? As a finance person, I cannot ask my team member. HR can ask them.
Now we will be asking somebody like a DPO or somebody. Okay, HR is also part of the system, but ultimately there has to be one person who is accountable, and DPO is a person responsible here, and the rest of the people will have to go along with him. The governance policy which we suggest is that there has to be a governance committee. Governance committee will be having the independent director minimum as a chairperson, not the promoter director, independent director where is available. Then the DPO will be there. Then all the stakeholders like your vice president marketing, vice president production, everybody should be part of that committee. And most of the decisions will have to be taken by the committee, not by an individual.
Sir, I have a practical question. I wanted to engage you as a consultant. I am an active insurance professional.
Yeah.
So where in which I can use your the professional expertise knowledge to my profession, because most of the time they are facing this kind of issues. So applicable to the court and the clients. Can you please explain on which area you can deliver the most fitting role to our day-to-day?
See, we are talking of a company taking a compliance measure. Okay, there is a system of audit. We have introduced our own system of audit called Data Governance and Protection Standard of India, DGPSI, which incorporates the best principles of ISO 27001, 27701, DPDPA 2023, plus ITA 2000, etc. Now, your company has to get yourself certified for this kind of a compliance. Then we will tell your board that you are not compliant. If you are not compliant, you take the risk. Of course, if the management says, I will take the risk, 250 crores I have got, I will take the risk. But that has to be done as a conscious decision of the management, not put on the head of the DPO or somebody like that. So our DGPSI system says that there has to be an implementation charter signed by the top management. I may be the DPO, but they cannot say, as DPO, you read a DPDPA, understand what it is and do it. But when I go with a proposal, they will not give you the permissions. Okay. So our compliance system says that implementation charter has to be signed and issued by the top management. So those are the things. Compliance measures need to be undertaken by the company. Your role is to see that your management takes such decisions. If you are not able to do it, buck stops at you. See, you are designated as a DPO. If you don't take it to your top management, then you have to suffer.
They are now managing the quasi-judicial authority, NCLT situation. So in this platform, I wanted to engage you for my data protection requirement, way in which you can come into the role and protect my company. That is what I want.
It's as part of the consultancy which we do in FDPPI. But the Act expects that one employee will be designated as a DPO. People outside can only give consultancy to you. But that is what we do. Our FDPPA has got all the support, which we will do. 7:30, what is time? Okay.
Sir, taking carry forward from Mr. Ravi. Bar are consulting and you are being hired by the company, suppose in position. And they are very layman. They don't know how to implement this. So what are the 3 or 4 layers which you want to implement, like data officer, then committee, and there is a so 4 steps you want to implement in that company from a very beginning so that the company is compliant.
See, for DPDPA 2023, we have identified 36 requirements. We call it as DGPSI Lite. Okay. If you have the 36 points covered, you will be compliant with DPDPA. Now, we have got another framework which is called DGPSI Full. It has got 50 implementation specifications. If you cover that 50 implementation specifications, probably you would have taken the best efforts to be compliant with whatever I'm talking of, not only this DPDPA, ITA 2000, the ISO standards, which normally whatever they say, and also in India, we are having a BIS standard. That is a Bureau of Indian Standards. They are coming up with a data governance and data protection standard. It is still in draft stage. It is coming. We have already incorporated that here. So we have that. So it is 1 or 2, if you say, organization has to be set up. I told you a committee should be there with all the stakeholders. Then one person accountable who is called the data protection officer. That is the first stage. Then this data protection officer should do what is called a risk analysis. Okay, gap assessment he has to do. He may use our services. We will say what you don't have. Okay. Then we will give a gap assessment report and give it to the management saying that, please look at this. If you want to cover this gap, okay, you issue that implementation charter. Suppose they say you have given 50 points, out of which 3, 4 is not relevant for me, or risk there is very low. We say, okay, you tell me that you don't want to implement that 4, we will consider it as absorbed risk. You have absorbed that risk. Next 46, you implement. So we will ask them to issue an implementation charter to the operating team, which is headed by this DPO. Okay. Then it's a question of what is to be done. One thing which has to be done is to look at where you have personal data in your organization. You have to draw an inventory. You have to have an inventory of personal data, inventory of processes using personal data, 2 kinds of things. Then you have to say, where is the consent? So where consent is not there, you have to incorporate that consent. If you want to use legitimate use, you should have a policy to say, okay, in this particular context, I don't have consent, but I can use it as per legitimate usage policy, section 8 or 9 of the DPDPA. So that way you are trying to reinforce your collection of personal data. Now, then when you collect it, you have to also determine how long you will keep it, who will access it. There is a security thing. When you will delete it. All these are part of the reasonable security practices. So you have to have an information security policy for that. So it's not 1, 2, 3, at least 7, 8 major things are there. And I told you 36 specific things are identified. But there is a step-by-step requirement which we have already done. That is what we are doing. FDPPA for the last 5 years, we started in 2018 when GDPR was there. Indian law was not there. In this 5 years, we have actually created a lot of certified data protection officers and data auditors. We conduct certificate programs, c.dpo.da. I should say that if any of your members want to become a data auditor, this is a necessary qualification. Okay. We are willing to, another director of mine is there. We are willing to actually give concessions and other things because we want this community to grow. So we try to certify professionals and make them capable of making this assessment as a data auditor. Then we tell companies that if you want to make an assessment of your company's this thing, we will give some of these auditors to help you in that. Then you implement appropriate technical measures, policy measures, and other things. We will give a certificate of compliance. We also have what is called a data trust score. That is, we give an evaluation in terms of like a credit rating, so that the company will have some visibility of where they stand. There, no other organization gives this kind of a end-to-end solution for compliance. That is basic training, both for your employees as well as for the specialists who can conduct the audits, and then certification for the organizations themselves. Data protect, this act has come only on August 11th. Full set of rules has not yet come. It will come anytime next week, 15 days. Okay. Then after that, there will be something called a data protection board. When the data protection board is constituted, people like us will go to them and say, we have got this DGPSI and other things, please look at it. And we are not expecting them to say that this is to be mandated or something like that. We want them to say that, okay, this is a framework which can be used, kind of a thing. Then they will introduce some accreditation for data auditors. It's possible. I'm saying, like in patent office, you have got a patent examination, a patent examiner's examination. Like that, they may have an examination. But we already have an examination for data auditors. If somebody has passed this, I don't think DPB will be able to create a better examination than what we have got in terms of knowledge. Okay, they may, like CAs and other things, they may decide to fail some people. That is different. That's a policy. Only 10% I will make them pass. So rest of the people I will fail. That is a different thing. But they cannot ask any questions which we have not already asked or we cannot ask in our future examination. So people who are trained by us are already capable of being data auditors. So this is what we are doing. We are willing to give that kind of a service to the companies. FDPPA has got about 400 members now, out of which about 23 members actually join hands with FDPPA to provide services. We are calling them as supporting members. So if I've got a company, it's not that I am going to do everything. We will have a consortium of our members who will be giving a proposal, and we will be working on that. So that is what we are doing. Okay, that is the question you had. Okay. So if you want to be data auditors, that's what I want you to actually start thinking, that why can't CMAs be also data auditors? If you keep quiet, tomorrow chartered accountants will become, say, they've already done that. They say information security audit, chartered accountants grabbed it. They went to the government and said, make all CISA audit by bankers should be done only by ISACA people. Am I correct? Okay. When it was done, they were not experts in information security. Okay. But afterwards, they might have learned. I'm not saying that they have got their own capabilities. They might have done. Others like Computer Society of India and others, I've always been telling, they did not try. Otherwise, Computer Society people actually should have been in the forefront of information security knowledge acquisition. After all, everybody is learning only now. This DPDPA has come only now. You will not get a person who say, I've got 10 years experience in DPDPA. No, they cannot have more than 3 months this thing. Okay, my previous experience is on other laws, which I'm modifying it for this. So this is a kind of new thing. And if CMA people start learning this, 3 years down the line, you will be as qualified as any other chartered accountant or anybody else with the kind of knowledge. It all depends on you. I would like to encourage your organization to think of it. That is what I was telling, that we are interested in creating a new opportunity for the CMA people. Okay, right? Okay. I will go as fast as possible. Basically, of course, discussion is what is important. Okay. So before we start looking at this compliance, the first thing we have to do is understand the applicability. Next, please. Understand the applicability. First of all, you have to, that is where this business impact assessment has to do. Is this law applicable to you? You have to first of all do that, no? Then understand your role. Then understand what are the obligations, 1, 2, 3, 4, 5. There are certain rights which are given to the public that also gets part of into the obligations. Then you can implement it. How you implement it? You buy some tools if it is required, have some policies, conduct training programs, make everybody aware. All these things is a normal this thing. Now, applicability, this act, you have to look at it. To what type of data it is applicable? To what type of entities which is applicable? Okay, it is applicable to personal data. It is not applicable to non-personal data. It is applicable to personal data for business purposes. Okay, if an individual collects personal data for domestic purpose, it is not coming under this. So these kind of things you have to first look at it. Similarly, type of entities. So the first thing you have to do is segregate your data into personal data and non-personal data. Okay. Then personal data is data about an individual. Non-personal data is everything else. Fine. Next, please. You have to be a little quicker. Okay. So there is next thing. There is a section 3 in this which talks about the applicability, which says this is applicable to digital personal data. It is not applicable to oral data and paper data. Okay. In fact, this act doesn't talk about protection of privacy. It only says protection or management of digital personal data. That is all it is. We call it as low-hanging fruits. No, the government has said that let me not talk about privacy and other big things. The 9 judges of Supreme Court were not able to define what is privacy. Please remember this. In the Puttaswamy judgment, they gave a 547-page judgment. They did not define what is privacy. Okay, they only said privacy is a fundamental right. Now, if they cannot decide as a CEO of the company, how can I say that I am going to protect privacy? So what we can do is we can comply with whatever law you say. If you say take consent, I will take consent. Now, whether that consent will protect privacy or not, I don't know. This is the law I'm trying to follow. That's why we focus on compliance rather than talking about the lofty things of we will protect privacy kind of a thing. But anyway, that government or Supreme Court somewhere may say that that is part of the data fiduciary's role. Okay. Then if anybody is processing, this basically is for data which is collected from India. If data is collected from outside India, let's say what we call as a GDPR data, DPDPA is not applicable to GDPR data. There is a confusion in many companies. If they say, I am already GDPR compliant, you are compliant with GDPR for GDPR data. GDPR data is information collected from EU region in connection with business in EU region. Whereas this act applies to data collected in India. From outside, if they are collecting data of Indians, that also comes under this. So that is first thing which companies will have to do. That is why we say in our DGPSI, jurisdiction-based classification of information is required. You will not find that in any other framework. You will not find it in 27701 or anything like that. It is there only in DGPSI framework. Okay. Then data which is not personal data, it is not applicable. Data processed for personal domestic purposes by an individual is not there, but an individual processing personal data for business purpose, it is applicable. There is no exemption for NGOs, no exemption for educational institutions or anybody else. So all of them at this point of time come under this act. When the rules come, whether they will give any benefits, we have to see. Otherwise, startups, there is no exemptions. There could be, under certain circumstances, some exemptions related to consent, but it is not a full exemption of the act. Okay. Even when exemptions are given, security exemption will not be exempted. Educational institutions, NGOs, FDPPA, your organization, you need to perhaps have, you may not be a significant data fiduciary. So therefore, you may not need to have a data audit or say DPO, but some of the other things like obtaining a consent will be required. You may have to send one email to all your members saying that consequent to the enactment of DPDPA, please give me permission for using your personal data, for sending invitations to various conferences and other things, or whatever is that, wherever you use, you have to identify how you are using the personal data and send it, or at least put it on your website. In your privacy policy, you may have to make the necessary changes.
Part of communication. How does that call for business purpose? It's not a business. The internal circular to all the members. I don't think it falls under the purview of DPD at all.
NGOs are not exempt as of today. Okay.
No, I'm talking about. Yes, they send out periodical circulars to all the members. So when they send out the periodical circulars to members, that is giving the dissemination of awareness to members saying it is on, it is not on, etc.
No, that is part of the consent which you have already taken for being a member. So it's a membership benefit. Okay. So within that it is there. But tomorrow, if you want to use it for any other purposes, you please remember that somebody may ask a question. Okay, NGOs are not exempt, is what I'm just trying to. Not circulars, but the name and address of the person to whom you are sending the circular is personal data.
No, institute is reaching out to the members for their programs. So dissemination of the information with institute itself is convening the program for the member, by the member.
That is part of the legitimate use. I am saying it is part of the legitimate use. Okay. Okay. But remember that if you are using it for any other purpose, for example, now I told you that FDPPA is going to give you some concessions in a say, training program. Now you want to communicate it to the other people, then somebody may ask, FDPPA is making money out of it. Okay.
So many unsolicited marketing. This Bajaj Finance is a minimum.
Big nuisance to everyone.
So how to avoid this?
You have to actually report it to the data protection board. That is the only thing which will happen onwards. As a data principal, earlier you had this mobile system, but nothing was happening when you give a complaint. You have got this, what is that, do not disturb kind of a thing. So now you have to file a complaint against Bajaj if you have received an unsolicited complaint. Okay. And hope that it will stop at some point of time. That's all.
Not stopping that. The legally at least.
No, this act has come only now. Nobody has been. Okay.
Something we have to react.
I have heard about Bajaj from a number of people. I don't know. A number of people have been.
The morning call from Mumbai, evening call from
So
Bangalore.
probably,
It's all data misuse.
why? No, there is also somebody like Cred. Cred, do you know? Okay. Okay, they are also collecting a lot of information and using it without any consent. There are a number of such things. Okay. It has to be slowly reduced.
But today I don't get anything from Bajaj Finance. 2-3 times when they call, you say, sorry, wrong number, they'll say it's incorrect information, they'll never call you. I'm not getting it.
Okay, okay. That is information which is publicly made available by the person.
Yes.
Okay. It is excluded from this. Correct. But if it is publicly made by the person himself. Okay. But if somebody has taken it without my knowledge and putting it there, that is not exempted.
All the things there, that they exempted. They told it is not covered under the.
Distinction is whether you have made it publicly available or whether they have extracted it. No, where from they have no, if they have extracted it without your permission, they are not supposed to use it. But see, the example which has been given in the act is a blog. Say, I've got Naavi.org. I only have put my name and address there, including my mobile number is there. I cannot say that that is private. So that kind of thing becomes public information. But if somebody has scraped, say, LinkedIn, and from there extracted it, I have not given them the permission. I have put it in LinkedIn for some purpose. Now, I have not authorized LinkedIn. Of course, LinkedIn will take my permission for certain purposes. That is different. Okay. If LinkedIn has given that information under a contract, then it may be okay. But somebody else cannot do a scraping of the data and then do it. That may not come under this public thing. You can ask a question to the person where from you got it. They have to show your consent. This consent, when you give, the onus of proof that a consent has been obtained is with that organization, not with the data principal. The data principal will say, I have not given consent. They have to prove that you have given the consent. I have got an email or something like that. So you have to, it's a tedious process which you have to perhaps do that.
Karnataka scrap that national education policy. The data I have, can I publish in that Facebook?
Which data?
So the number of the schools which are not being allowed to have national education policy.
That is not personal data.
But they have, the government of Karnataka, I have sent an email.
It's okay. That is not personal data. It is corporate data or environmental data or something like that.
So I can publish.
You can publish it. It doesn't come under DPDPA. You have to check whether it is coming under confidential information or something like that. I don't think it is confidential. You can perhaps do it. Yeah. Yeah. But personal data is different. Say in a school, the names and addresses of students is personal data. If you have collected that, then it's maybe different.
I have taken from RTI the total number of.
No, if a public authority has got the right to disclose it and they have disclosed it, that becomes public data. Like individual on his own publishing, if an authority has the right, like in the RTI, and they have published it, that is also considered as public data. It is not coming under the restrictions. Yeah.